我希望这个 keynote speech 能够给各位同学不一样的想法，不一样的感受。那我想这个 keynote speech 找了外国的法官来，这个也是跟我们所长刚跟各位同学所讲的，我们这个律训希望给各位同学打开视野，是在这个目的底下我们去进行的。那以下我就请我们所长，谢谢。
好，谢谢伯祥。Honorable Judge Craig S.Iscoe， 还有我们黄志豪黄律师，陪审团协会理事长郑文龙郑律师，还有台北律师公会严华兴严副秘书长，你坐在那边后面看不到你站起来让他看看。台北公会的专任副秘书长，他事实上是有律师资格的啊。郑文龙郑律师他是陪审团协会的这个理事长，各位最近也在媒体上可能会经常看到他。黄志豪律师，他是这里写的啊，这里是叫葡萄酒讲师、瑜伽师、口译师那现在当然也是律师，他是我以前的同事，非常非常的优秀啊，他们几位。不过我想我还是要在这边要介绍我们今天的主讲人这个Mr. Iscoe，Judge Iscoe，他是美国 Washington D.C. Columbia 高级法院的法官，从2003年到现在，是Georgetown 的这个 LLM， 然后 Stanford 的这个 JD， 然后德州大学的 BA， 那在过去除了担任过检察官，担任过法官那也做过Georgetown 这个 Law School 这个Law Center in Washington D.C. 的客座教授。那么我想今天我们很高兴邀请到这个 Craig S.Iscoe 法官来跟各位做介绍。那么待会会由黄志豪黄律师来担任口译的工作。我们是不是热烈的欢迎Iscoe 法官 Mr. Craig S.Iscoe。 Thank you。刚才 Iscoe 法官说，他说他可不可以讲一点笑话？我告诉他，我们比较 prefer 讲笑话。我们是不是再度的欢迎 Mr. Iscoe, Judge Iscoe？
Thank you, Mr. President, for that very kind introduction. At least, I hope it was a kind introduction because I don't know what you said.
那么非常谢谢理事长刚刚这个非常诚恳仁慈的一个简介，但至少他们希望，因为他听不懂他希望这是一个好的简介。
It is truly an honor to be here in front of people who are beginning their legal career, who are going to be the future of law practice in Taiwan.
那么今天能够在场呢，在成为台湾众多日后在法律业界职业的这个新血面前来做这个演讲是法官的一个荣幸。
Yesterday, I participated in and watched a day-long moot court on the jury system, and I was very impressed by the lawyers and the judge who appeared there.
那么昨天呢，法官有机会在这个东吴去参加了这一次的陪审团模拟审判。在历经了1天的一个准备程序之后，法官认为他对他所看到的法官以及这个审检辩三方的一个互动，他觉得非常的印象深刻。
And now I'm delighted to be in front of all of you who obviously are very skilled in the law and very smart because you passed a very difficult bar examination.
那么今天因为大家他觉得非常荣幸，因为可以在显然大家都是很聪明，才能通过这么艰难的司法考试能在这边给大家做一个演讲，他觉得非常的开心。
And I want to thank the President for inviting me here and Mr. Jerry Cheng, Mr. Leon Wong for all that they have done for the pursuit of justice in Taiwan.
那么法官也希望表达他对于我们理事长、所长，还有那个陪审团郑律师以及我们在地工作人员帮忙，那么希望可以就是说对台湾的司法正义有所贡献。
Today I'm going to talk about the rule of law.
那么今天呢，我们所谈的主题一开始会从所谓的依法而治或者法治作为一个开场。
And I'm going to talk about what rule of law means, why it is important, and what roles lawyers can play in implementing it.
那么这个重点会在第一个，就是说，到底所谓的法治或依法而治是什么意思呢？其次的是，为什么法治对我们这么的重要？第三个重点则是，到底律师在法治里面扮演着什么样的角色？
I'll also talk about the relationship between the rule of law and the jury system.
那么当然，正如刚刚理事长所讲到的，这一次来主要目的之一也是希望告诉大家，法治的概念跟陪审团的审判，也就是人民参与之间有什么样的关联性。
And I'll talk about some of the difficulties that following the rule of law can cause.
那么其实法治的道路并不轻松啊，法官也会跟我们分享，在所谓坚持法治的路上遇到一些比较艰难的案例是什么。
So what is the rule of law? I will tell you the term meant very little to me when I first heard it.
那么究竟什么是法治呢？他希望跟大家分享一下他一开始所听到的讲法。
So, as is written here, the rule of law is the legal principle that laws should govern a nation's citizen and a nation's leaders rather than the citizens being governed by the arbitrary decisions of the leaders.
那么其实所谓的法治啊，就法官自己的理解，以他所取得的一个概念，应该是一个国家的这个政府跟人民同受制约约束的一套基本规则，而不是由政府来给人民下一套规则，要求他们遵守。
Now, as you know, the United States is not the only country with the rule of law.
那么当然各位都理解哈，美国并不是世界上一个唯一的一个法治国家。
Taiwan follows the rule of law and has followed it for many years.
台湾也是一个法治国家，那么依法而治也有相当的年份。
And almost any country that has elected leaders rather than monarchs who take power by inheritance or dictators who take power by force, almost any country that doesn't have those follows the rule of law.
甚至基本上说来呢，只要是这个国家不是靠王室的一个继承来传承权力，或者是由军事独裁者的强人用军事方式取得政权的话，都可以称为是一个法治国家。
So when I talk about the rule of law in the United States and how we apply it in our criminal law, our civil law, and our juvenile justice systems, I am not saying the U.S. system is better.
所以希望各位可以了解，当法官今天来到现场跟各位分享美国在刑事、民事或者是少年事件制度底下的一个法治精神的时候，他的用意并不再强调美国的法治比较好。
I'm saying only that we've had the system for longer than most countries, so we've had more time to make mistakes.
相反的，它的重点是，正因为美国有比较施行法治比较长的时间，所以它有更多犯错的机会。
And I hope we've also had more time to learn from the mistakes.
那么当然也希望我们大家可以从这些错误的经验中汲取更多的好的学习的教训。
And today I want to talk about what we've done right and what we've done wrong so that you, the newest lawyers in Taiwan, can learn from that.
那么今天我们就希望跟这一批台湾司法正义的新血分享一下，到底过去以来在美国什么做对了，什么做错了。
And if you have questions about what I'm saying, I encourage you to ask them at the end.
那么如果各位对于法官所讲的有任何问题的话，欢迎各位在演讲的最末可以提出您的问题。
What is important about the rule of law is that it is considered better than the decisions of good, benevolent leaders who make decisions that are not based on the law.
那么常被拿来跟法治相提并论的是，如果有一个比较良善、利益良善的一个领导者，他并不是依据法律来做统治的话，哪一者会比较好呢？大家还是会认为法治是比较好的。
In a country that follows the rule of law, you don't have to depend upon what the leader does. The law makes the leader do what is required.
在一个法治国家里面，最重要的是，你不需要常常祈求这个领导者以他的人治或他的理智来做的决定，而是你知道有一套规则、一套法律，会告诉你这个人所做的决定受到什么的拘束。
The basic concept is that the citizens should be governed by a written law.
那么当然，这里面最基本的概念就是说，所有的公民都受到同一套的法律的这个制约或者约束。
And sometimes this idea is described as a government of laws and not of men.
那么具体来理解呢，这就是一个所谓法治政府，而不是人治政府的概念。
Others describe the rule of law as giving citizens freedom from the tyranny and the personal whims and prejudices of dictators and kings.
那么有些人呢会这样描述法治啊，他们说法治其实就是一套制度，让人民有免于受到暴君或独裁者基于本人的意志或独断或偏见所侵扰的自由的制度。
And you have to remember when the United States adopted the rule of law, it was fighting for freedom from England from tyranny imposed by a king.
那么其实各位或许可以理解，当初美国的建国之初呢，之所以为了建立法治政府，就是因为他们对抗的是当年的英国的一个暴虐的人治。
So it was very important to protect against a leader deciding people's lives and fates without being governed by any laws.
那么因此呢，如何想办法去对抗一个靠着自己的想法而不受法律约束的一个领导者，对于人们的自由、生命、财产产生的侵害，就是法治精神的基本概念。
In the United States, we like to quote Greek philosophers. We do that because we think it makes us look smart and well educated.
那么在美国呢，我们都很喜欢引用这个所谓的希腊哲学家的话，因为这样听起来比较聪明哈。
So, I will now quote Aristotle so you will think I'm smart and well educated.
那么现在我要引用亚里士多德的话，大家就觉得我好像很聪明啊，受过良好教育。
And Aristotle said, the rule of law is better than that of any individual.
那么其实亚里士多德讲得很清楚，他说依法而治其实胜过于任何的个人统治。
So, what are the characteristics of a rule of law system?
那么一个依法而治或者法治的系统或制度，它有什么样的特色呢？
And number one is there is a constitutional or overarching structure.
那么第一个特色是，它一定有一个所谓宪政底下的或一个大概的一个架构。
There is a legal hierarchy that controls the interrelationships of other laws, rules, and regulations.
具体来讲呢，它会有一个所谓的法律的层级观念，来控制法律规则跟规章之间的彼此的互动关系。
In the United States, we follow the U.S. Constitution. And I bring the Constitution with me everywhere, and I will show you. It's very small.
那么在美国呢，其实他们当然是依据着所谓的美国宪法来做决定。那么今天法官就把他的宪法随身带的这个随身本带来，大家可以看一下，其实小小薄薄的一本而已。
But in the Constitution is the overarching structure that controls all of the laws in the United States.
那么但是呢，在这个宪法里面，最记载着控制整个国家法治层级最重要的基本架构。
Every law must be consistent with the Constitution.
所有的法律都必须跟宪法不相违背，相符合才可以。
So if I want to find out whether a law is proper, I look at the Constitution.
所以当我希望找出来哪一个法律它基本上是不是合宪的时候，我回归到宪法去寻找这个内容。
And if I want to find out why in the United States we have jury trials, I look at the Constitution.
甚至例如说，法官希望回头去找说，到底什么地方认为美国应该采行陪审制的时候，他也会回到宪法去找寻这个依据。
And I will talk more about jury trials a little later.
我们等一下会再谈到陪审团制的一些相关的特色。
Okay, so the first characteristic is we have a constitution.
所以第一个有宪政制度，
And of course, you have a constitution as well. The second one, oh, let's see if the second rule is the constitutional structure is supreme and it's interpreted by a constitutional court.
法治的第二个特色是什么呢？就是宪法在法律里面具有最高的层级位阶，而且只有这个宪法法庭有权来做一个诠释。
As you know, law is about words and figuring out exactly what the words mean.
那么相信各位都很理解哈，在你读了这么多年法律之后，法律其实基本上就是文词的汇整，以及如何诠释这些文词的方法。
So we have the Supreme Court to interpret what the very few words in this Constitution mean, and they write many, many thousands of pages of words to decide what these few words mean.
所以在美国呢，就有美国联邦最高法院的法官有权利来对这本薄薄的宪法里面写的这些简单的字，做出了成千上百篇的数以万字计的判决，来告诉大家这些宪法的字是什么意思。
And one of the important principles of a constitution is that it limits what other branches of government can do.
那么宪政制度一个特色是呢，它对于政府各个机关的权力做出了明确的界定跟限制。
So let me give you an example. What does it really mean? What does a constitution mean? So here's an example.
那么接下来我们看一下，举一个例子，在宪法上到底它是什么意思？
In the United States, our Constitution says that senators serve 6 years and representatives serve for 2 years before they face re-election.
那么依据美国宪法呢，他们的所谓的这个参议员呢，基本上每一任是6年，那么众议员每一任是2年的任期。
So the House and Senate are responsible for passing laws. What would happen if they thought, I don't want to run for re-election every 6 years or every 2 years?
但是基本上在美国，立法机关是由参众两院去分享立法的权利。所以如果有一天，当参议院跟众议院决定说，哎呀，我觉得每6年或每2年还要再重选一次，很麻烦，那他们该怎么办？
Why don't we just pass a law that we all serve for 10 years? Or it could be 20 years, because then we can just stay here for a really long time.
那不如这样好了，作为立法委员很简单嘛，我们就自己过一个法律，可以做10年或20年任期，这样我们就不用常常重选了。
And after all, we pass the laws, let's just pass our own law.
那毕竟我们是立法者嘛，我们就立一部关于我们自己的法律也没有问题啊。
But they can't do it because the Constitution says no. The Constitution is supreme.
那当然这是不行的，为什么？因为国家最高位阶的宪法已经明白地指出这是不可行的。
Okay, in the United States, we have 3 branches of government. Here you have 5 UN, but it's the same idea. There are different branches.
那么在美国采行的是3权分立的基本制度，虽然说在台湾有所谓的5权分立，但基本上设计上应该差不多。
We have the executive branch, that's the president and all of the agencies, the Department of Justice, the Department of Commerce, and other agencies.
那么第一个呢是所谓的行政机关，以总统为首，那旗下有包括这个法务部啦、商业部等等这些行政机关。
We have the legislative branch, which I just talked about, with senators and members of Congress.
那么有立法机关，包括了参众两院。
And then we have the judicial branch, the judges and everybody who works for judges and for the courts.
那么最后一个是司法权，司法机关当然就包括了法官以及法官所属的这些工作人员。
But it's important to recognize that lawyers work in all 3 branches.
但是各位需要体验到一个非常重要的事实，律师的角色在这3权里面都存在。
So lawyers work for the president and the agencies.
所以你会看到，在行政机关跟总统的旁边一定有律师在。
And lawyers work for members of Congress, and lawyers also work for judges.
那么当然你也会看到，在立法者的身边，乃至于在司法者的身边，都有大量的律师存在去辅助这些人。
The third principle in a rule of law system is that no person is above the law.
接下来是法治的第三个特色，也就是无人可以凌驾在法律之上。
This means no person is above the law because of race, or gender, or age, or wealth, or any other reason.
那么这代表了呢，没有人应该因为他的种族、性别、年纪、他的资历、社会地位等等，而遭受到在法律上不同的对待。
And they're also not above the rule of law because of their position in government.
那么当然也不会因为他在政府里所担任的职务而受到不同的对待。
So the president and members of Congress and powerful people are just as governed by the rule of law as the lowest level person in the country.
那么因此呢，不管是上至总统乃至于一般的平民呢，这些人在一个法治国家里面所受到的法律约束基本上是平等的。
So let me give you an example. A law that said African Americans could not live in certain parts of a city, that would be unconstitutional. It would violate the rule of law.
举个例子来讲好了，美国多年以前曾经有过这样的案例，这个法律规定说，某种特定肤色或种族的人不得居住在城市里的特定地区之外，那么这个东西就是违法的。
But I want to add that even though the Constitution is clear, that doesn't mean that the courts in the United States were always good at interpreting its provisions regarding blacks or women or many other people.
不过法官也希望强调啊，即使美国的宪法写得这么的清楚，但是在多年以来，美国的法院适用这个宪法或诠释的过程里面呢，也并不表示他们所得到的结果，往往是对弱势族群，包括黑人或者妇女等族群，是一个平等或有益的一个诠释方式。
That's what I mean when I say we have learned from our mistakes. In the U.S., there were laws against many against blacks and Asians and Jews that were legal for many years until the court finally said, no, they violate the Constitution.
那么其实这正是法官一开始跟各位指出说，在美国的制度底下有非常非常多的问题的地方。因为呢，其实到后来法院最终做出一个合于法律的判决之前，美国的少数族裔，包括黑人、妇女、亚裔等等，已经多年的受到不正确的法律或者错误的法律的一个约束。
It took a long time for the Supreme Court to recognize what to me is very clear.
那么其实呢，要让最高法院这样的宪政诠释机关去认识到说这些基本的规则的时候，也花了相当久的一段时间。
But ultimately, the rule of law prevailed.
但最终呢，法治的力量还是会取得优势。
And for all of you, you can play a role in Taiwan in making sure the rule of law prevails.
那么各位在这个里面的角色就是，各位在未来一定可以在台湾的司法制度里面为依法而治扮演了非常积极正面的角色。
And I hope you can learn from our mistakes.
那么我深切的希望各位可以从美国犯下的错误里面去做学习。
Rule of law, the fourth characteristic is, as I mentioned before, public officials are not protected from prosecution.
那么第四个特色是，公职人员呢，一样也不能够豁免于法律之外。
This means that someone who holds high office still must follow the law.
这表示，就算你担任的公职职位再高，你依然必须要接受法律的约束。
It does not matter whether that official is elected or appointed, he or she must follow the law.
无论这个公职人员是被选举出来的，或是被任命的，他都必须要跟随这个法制。
And I should tell you that I spent much of my career before I became a judge prosecuting public officials who were corrupt.
那么，其实法官希望跟各位分享，在担任法官之前，他花了非常多年担任一个检察官，专责追诉的就是公职人员的这些贪污或者是政风的案件。
And I strongly believe that public officials who use their positions to defraud or cheat or deprive the citizens of their rights are among the worst kinds of criminals.
那么法官本人也相信其实呢，这些身在高位的官员，如果运用他的职权上的能力去不管是侵占或者是侵害一般市民的权益的时候，他认为这是最糟糕的一个类型的罪犯。
I want to give you a couple of examples. A senator may not commit a robbery without facing a criminal charge. That just means that the regular laws against robbery also apply to high-level officials.
那么举个最简单大家都可以理解的例子，一个参议员当然不可能豁免于所谓的强盗罪的追诉之外，这表示了强盗罪的这个法律概念呢，对所有人都有适用。
But there are also laws that are specifically designed to ensure that public officials not misuse their office.
但是有些法律特别是被设计来确保这些位居高位的这些官员不会滥用他的职权。
So public officials cannot take bribes, including money or gifts, in order to do things or not do things in office.
那么无论在这个任何的情况下，一个公职的官员，一个公务人员呢，无论是职权与否，行不行使，他都不得收受任何形式的金钱报酬或者馈赠。
And what do you think? Is a judge a public official?
各位认为法官属于这个所谓定义的公职人员之下的一份子吗？
And of course the answer is yes. And a corrupt judge is among the most disgraceful public figures.
当然是的。事实上，法官认为一个贪污的法官应该是在这里面最糟糕的一种类型。
And that gets to my fifth characteristic of rule of law. Corruption of any kind is strongly discouraged. It is actively investigated and prosecuted at all levels.
法治之下的第5个特色是呢，任何形式的贪渎都是基本上应该受到制止的。因此呢，政府有义务主动的去调查，并且去惩罚这样的行为。
And although this concept is widely accepted in the U.S., that isn't true for all countries.
那么这样的概念虽然在美国已经行之有年，不过并不是全世界每个国家都认同这样的概念。
A few years ago, I spoke about public corruption in the country Croatia.
那么在几年前，法官有这个机会到克罗埃西亚去对一群法官做演讲。
And I gave an example of a public company that was putting poison pollutants into the water.
那么他举了一个例子说，当时有一个上市公司呢，他不断的用这个排放物在毒害地下水。
And I talked about how that company would be investigated in the United States.
那么他也提到说，如果是这样的一个公司在美国的话，应该会受到何种程度的调查。
And the judges I was talking to said, "No, that's impossible."
那么他那天所讲的这个对象，那些法官跟他说，这个在我们国家不可能发生。
They said, "The company is the same as the government, and the government never prosecutes itself."
他说呢，因为这个大公司基本上跟政府没有两样，那政府是永远不会去追溯他自己的人的。
They said the government can do whatever it wants.
那他们的想法是，政府可以为所欲为。
And that's a central principle of the rule of law. The government cannot do whatever it wants.
但这就点出了法治的最核心概念：政府是不可以为所欲为的。
The government and its officials are controlled by the Constitution and the laws.
政府以及官员跟公务人员都受到法治概念以及宪法的规范。
Now, characteristic 6 is the fundamental political and civil rights are guaranteed and are all upheld equally.
那么接下来是法治的第6个特色，也就是呢，基本的政治与人权应该被平等的去维护。
But you might be asking, have you always done that in the United States?
当然，这时候心里各位就会浮现一个 OS 说：难道你们美国人真的就这样子吗？
And again, sadly, the answer is no.
那么很诚实的答案是，其实在美国并非总是如此。
And I've given some examples. I could talk a little bit more about some of those examples. For many years, women could not vote. They said, men can vote, women cannot.
举个例子好了，其实一直长久以来呢，在美国的女性，一直到某个时间点之前，她们是没有投票权的，只有男性具有投票权。
In criminal law, but then things changed. People understood the Constitution more, and views changed as well.
那么后来，大家对于宪法的理解增加了，也因此开始改变这样的状况。
For many years, there was no question that the Constitution, which says that there is a right in a criminal case for a defendant to have a lawyer.
那么其实呢，在宪法里一直都规范说，一个刑事被告具有聘请律师或者受律师所代表的权利。
So the Constitution said, yes, you have a right to a lawyer, but if you can't afford a lawyer, that's too bad. You still have the right.
但是问题是呢，对于这个法律，对于这个宪法的诠释，很多人会觉得说，没错啊，宪法是说你具有聘请律师的权利啊。问题是，如果你自己资历不够，没办法聘请，对不起，那是你的事情。
But finally, the Supreme Court said, if the right to have a lawyer means anything, it means that everybody should have a right. So if you can't afford a lawyer, one has to be appointed for you and paid for.
那么最后，美国联邦最高法院终于对于这个东西做出了诠释。他说，如果我们希望这个宪法的条文真正的具有任何形式的意义的话，它就必须被解释成为：当你没有资历聘请律师的时候，政府有义务帮你聘请一个律师。
So that right to have a lawyer appointed for you and paid for was in the Constitution, but for 200 years, nobody really knew it.
所以呢，回到我们刚刚讲的，其实这一条一直都记载在这个律师权的条文，一直记载在美国宪法。但是200年之间呢，并没有任何人对它做出比较有意义的实施或诠释方式。
Similarly, the Fifth Amendment to the Constitution says that no one can be compelled to testify against themselves.
那么再举个类似的例子好了，美国宪法第5修正案指出呢，任何人都有不自证己罪的权利。
So what that means is, if you're charged with a crime, nobody can call you as a witness and say, "Tell us what happened."
这个意思是什么呢？是假设你被控犯罪，没有人有权利把你用证人的身份传到法庭上，要求你告诉大家发生了什么事情。
But for many years, the police never told people who were arrested that they had that right.
问题是在美国的司法实务上，非常多年以来，警察机关从来不会告诉被逮捕的嫌犯或被告说，你有权利不说这些话。
Instead, they threw them in a jail cell and said, "Tell us what happened."
那么反过来呢，警察会说，没关系，我先把你押起来，你慢慢想，再告诉我们发生了什么事。听起来好像很耳熟哈。
And most criminals, or most people charged with a crime, did not pull out the Constitution and say, "Wait a second, the Fifth Amendment says I don't have to talk."
那么这个时候，其实你会看到大多数的嫌犯或被告也并不会拿出一本宪法说：“你看第5修正案说，我有保持缄默的权利啊。”
And it wasn't until the Miranda decision, and everybody has heard about the Miranda rights, that the Supreme Court held the police had to tell you you had a right not to say anything.
那么这也是一直到所谓的米兰达对亚利桑那州 Miranda vs. Arizona 这个案例，最高法院才真正决定说，警察必须要告诉嫌犯或者被告，你有权利保持缄默。
So once again, the right was in the Constitution, but it took well over 150 years for the Supreme Court to clearly identify that right.
所以各位看啊，虽然这一条一样在美国宪法上已经行之有年，但是也花了150年的时间，才由最高法院做成一个裁定来做这个事情。
And that brings us to our next characteristic. All security forces are subservient to the civilian government.
那么接下来呢，我们要讨论法治的第7个特色，也就是所有的军事武力集团都应该臣服于一个平民的政府。
And in the United States, the president is the commander-in-chief, and he controls the military.
那么在美国呢，总统事实上也就是3军统帅，他可以控制所有国内的军事部队。
The military and the police answer to the president.
而军跟警呢，当然也只服从3军统帅的领导。
And this is very important because if there is a military government, it has all the power. If you disobey, the military can make you obey.
为什么这一点很重要？各位可以想一下，如果今天你有一个军事政府的话，这代表什么？这个政府有权利使用武力，让你在任何时点对于任何规定做出一个臣服的动作。
So in the United States, there are many famous examples of the president firing a powerful general.
那么其实在美国你就会看到这种类似有名的案例，是总统把一个很有权力的将军给 fire 掉的例子。
And the next characteristic, and I think I numbered it wrong, the next characteristic is the judiciary is independent from undue influence from executive, legislative, and special interests.
那么下一个法治的特色其实跟司法权有关，那就是司法的一个独立呢，基本上不应该受到行政、立法或者任何形式特殊利益的不正影响。
So what does that mean?
什么意思？
Let me give you an example. Many times, Congress does not like the way the Supreme Court interprets a law that Congress has passed.
举个例子好了哈，其实在美国的司法史上，很多时候立法机关像国会，通常不太喜欢最高法院做的一些判决。
So what if Congress, to retaliate against a bad Supreme Court decision, said, well, we can't fire the Supreme Court justices, let's just cut their salary in half.
那么这个时候，如果国会他不喜欢最高法院大法官做成的决定怎么办呢？既然我不能够把你 fire 掉、解雇掉的话，那不如我把你的薪水减半如何？
That would be a violation of the Constitution, and they cannot do that, although long ago they tried.
那么当然了，这是违宪的。虽然说之前确实他们的国会有试过要做这个事情。
And the president also cannot promise a judge, well, if you vote to uphold a law I support, I'll nominate you to the Supreme Court.
那么当然，总统再举个例子啊，总统也不能够对一个下级法院的法官说，如果你做怎么样的特定判决的话，下次某一个法官的席位，我就会提名你。
I can't tell you that that's never happened, but it would not be legal.
那么我不敢保证这在美国史上从来没有发生过，但重点是那是不合法的。
And that's what's important is that the judges have independence. As a judge, I do not have to rule the way anybody tells me to rule.
那么这个观念的核心是什么呢？司法权行使的独立性质，也就是作为一个法官，他不需要受到任何人的影响来做判决。
And although I was nominated by the president, I don't have to say, what would the president want me to do?
也因此，虽然法官是由总统所提名任命的，他并不需要在判决的时候考虑到总统的心情是什么。
Instead, I and every other judge asks, what does the law say? What does the law mean?
相反的，身为一个法官，应该时时刻刻考量的是法律的真意、法律的文字是什么东西。
Because we follow the rule of law.
这是法治的结果。
And judges may disagree about what the law means, but those agreements are based on interpretation of the law, not what on somebody tells them to do.
虽然说有些时候每一个法官之间对于某些法律的看法可能有所不同，但是这些歧义乃是出自于对于法律的解释，而不是因为受到不正影响的结果。
And I want to give one more example. In the U.S., we don't always strictly follow what the rule of law tells us to do. Franklin Roosevelt decided that he did not like what the Supreme Court was doing. He knew he couldn't reduce their salary. He knew he could not fire them because they served for life.
那么再举个例子好了哈，美国总统罗斯福呢，其实有一段时间他并不喜欢他那一任期的这个最高法院，那他知道他不能够把他们免职，也不能够减薪。
So he decided, instead of 9 people on the Supreme Court, why don't I have, I think it was 15 justices.
所以他就想说，好吧，9个人既然没办法让我处理的话，我不如把它增加成15个人，这样我可以多6席的提名机会。
So if I appoint 6 more justices, they'll probably do what I want.
那你看，我如果多了6席的提名权，那很显然我就比较有机会控制最高法院。
But what was called the court packing plan was largely agreed would not be constitutional.
那么最后呢，这个所谓的包裹最高法院的这种想法呢，已经被认为是违宪的。
Okay, the final characteristic of the rule of law is access to justice in criminal cases, in civil cases, and in all public matters is fair and reasonably expeditious.
那么最后一个法治的重要特色是，对于正义，无论是在刑事、民事或者是公共事务的行政案件里面，对于正义的取得，基本上都必须是公平的，而且相对合理迅速的。
But what does fair and reasonably expeditious mean? That is the subject of much dispute.
那么当然了，所谓什么是公平，什么是相对合理的一个迅速，这都是有相当多的争议以及诠释空间的。
And you, as lawyers, help decide, help influence what fair and expeditious mean and what every other word in the law means under the rule of law.
那么各位必须铭记在心，身为一个律师，你的职责之一就是帮助大家决定到底什么是所谓的公平，什么是相对的迅速、相对合理的迅速，以及其他一些法律里面重要的概念。
I've given a couple of these examples already. So why is the rule of law so important?
那么讲了这么多，回到我们当初讲这个keynote speech 的重点，为什么法治有这样子的重要性？
And I've told you, it influences how a country is run.
第一点是因为法治会实质上影响到一个国家如何的运作。
No one is above the law, and no one is denied the protection of the law.
没有人应该凌驾于法律之上，没有人应该不受到法律的保护。
But the rule of law cannot exist without lawyers.
那么最大的重点来了，一个法治的系统没有律师的支持是绝对不可能存在的。
There always will be people who intentionally try to subvert the rule of law.
在任何一个体系里面，永远会有人，不管是不是当权者，有意图的去改变这个所谓法治的本质。
And there are many, many others who unintentionally undercut or do not follow the law.
那么在很多其他的情况，当然有许多人他并不是故意的，但他依然想办法去所谓的这个减低这个法治程度的影响。
So what can you, as lawyers, do to enforce the rule of law?
那么各位身为律师心血的一员，你应该做些什么来帮助大家实施这个所谓的法治呢？
You can protect the rights of criminal defendants.
第一个非常重要的是，各位应该设法竭力的保护刑事被告的所有权利。
In a criminal case, whether you're a prosecutor or a defense attorney, you can make sure that the police and law enforcement officials always follow the law.
那么在一个刑案里面，各位不管是日后有机会担任检察官，或者是担任律师、辩方律师，你都必须要尽力的确保执行法律的机关，他是想办法去遵守一切的正当程序，也保障了被告的权益。
If you're a prosecutor, you make sure that you are zealous and you don't make decisions that protect the wealthy or powerful. You treat everyone equally.
那么如果各位当中有人有机会后来担任检察官，不要忘了，除了应该竭力的履行你的职务之外，你也必须记得你要相对平等的去保护每一个人的权益，不应该依据一个人的地位或者是财富而有不同的一个对待方式。
And whether as a lawyer you're practicing in the civil area or criminal area or administrative area or transactional, any kind of law, you must obey not just the law, but all procedural rules and regulations.
那么作为一个律师呢，不管各位日后职业的领域是在刑事、民事或者行政案件里面，各位不仅仅要遵守法律，也同样的必须设法去保障这个程序上或者是相关法令规定各种规章的一个执行。
So in serving your client, you find ways to follow the law that meet your client's needs, but you never ignore the law, disobey the law, or counsel a client not to follow the law.
那么因此在职业的过程里面，你应该做到的是设法一边去符合你当事人的需求，但同时去追逐法律上最大的利益，也就是遵守法治的一个状况，而不是呢透过违反法律的方式，或者去告诉你的当事人说有哪些这个所谓的推翻法律的方式可以做。
And you use the courts to challenge rules, regulations, and laws that you believe violate the Constitution or other controlling standards.
那么接下来很重要一点是，各位在职业的过程里面，偶尔会遇到某些法令或规章，你认为是有问题的，是违背你的信念的，或者不合宪的。这个时候，各位必须要很热诚的，或者很竭力的利用法庭作为一个工具，去推翻这些你认为有问题的法令。
So you remember when I talked about all the mistakes that the United States has made? It was lawyers who challenged the laws and said they violated the Constitution that led to the changes in the interpretation of the laws that led to more freedom for individuals.
那么各位不要忘了，我们今天举了非常多在美国司法史上国家犯下错误，最后终于得到更正的这些案件。但是谁在背后推动这些改变？是律师，他们借由每一个案子的诉讼，让国家最后，让司法机关最后做出了正确的一个判决。
So as lawyers, use the courts and pursue justice.
所以担任一个律师的话，你的职责是利用法庭去追求正义。
And if you see corruption, promptly report corrupt actions by government employees, police, judges, or other lawyers.
另外一个很重要的概念是，如果当你看到有所谓的贪腐的状况的时候，不管它是发生在政府、公务人员、相关的一个聘雇人员、警察、法官或者是其他律师身上，各位的义务是立刻把这个事情举发出来。
Don't ignore corruption and say, well, somebody else will deal with it.
不要认为说这个没有关系，反正其他人会处理这个事情。
Now, I've given you only, of course, a partial list of the things that you can do as lawyers. Doubtless, you will think of more.
那么当然，我们今天所提到的只是一个部分的一个清单哈。那么各位在职业的过程，一定还会想到更多律师跟法治相关的一个执行层面的问题。
And you, as new lawyers, are in an exciting and powerful position.
那么各位呢，作为律师界的新血，其实现在所面临的正好是一个非常令人兴奋， 而且非常有趣的一个十字路口。
You can use your legal training, your intelligence, and your integrity to fight for the rule of law and enforce the rule of law in Taiwan.
那么各位将会有机会可以运用你所多年所受的法律训练，你个人的良知跟你的正直，去为台湾司法正义的一个法治来做一个贡献。
I wish you all the best in your legal careers in Taiwan.
那么法官在此谨祝各位在日后职业的过程里面一帆顺利一帆风顺，对台湾的一个司法正义也有所贡献。
谢谢。
谢谢各位。
Thank you, Honorable Judge Iscoe. Thank you again. Thank you for your excellent speech. 好，那么律师在法治社会里面到底他的角色是什么？他可以扮演什么样的角色？我想他今天给大家的这个1个钟头，非常精彩的这个演讲，我们要特别感谢Mr. Iscoe, Judge Iscoe 给大家带来的启发，我们是不是再度的谢谢Iscoe 法官？我想花2分钟的时间，在今年我们全联会出席了相关的一些会议，无独有偶的，大家都谈到同样的一个主题，就是 Rule of Law。在今年1月份，我跟严华兴严副秘书长一起去香港参加了香港的法律年度开启典礼啊。各位晓得，去年香港有一个类似我们台湾去年的学运的一个活动，在那个活动之后，很多人在香港也在谈到 Rule of Law 啊。香港的大律师协会有一位他的前任的会长叫石永泰。对于法治有非常精辟的见解，各位也可以上网去看啊。那么这个香港大律师协会这个 Barrister 石永泰律师对于法治的精辟的见解。那么今年3月份，我也跟副秘书长去德国的柏林参加一个 International 这个 Lawyer 这个 Forum， 在那个 Forum 里面的主题。也是谈到 Rule of Law 以及这个所谓刚才的第9个特色吧，就是法治的特色，就是 Access to Justice 我想刚才我觉得为什么会说今天这个 Judge Iscoe 给各位的这个题目在我来看，对于律师的职前训练也许是更贴切了更贴切，有很多的启发，各位也许从这个题目去思考，去上网。我刚才提到的，包括在香港的施永泰大律师的这个在香港的那个演讲，以及今天Judge Iscoe 给各位的这个启发，我相信对于各位从事律师工作之前有这一个法治的观念，我想是非常非常的有意义。我们再度的要谢谢Judge Iscoe， 我们要致赠一个简单的礼物给他。
Honorable Judge, and I have a question regarding to the war against the terrorism in recent years. How the judiciary and maybe the lawyers deem that recent war against the terrorism, because some people demand the executive more power to against the worldwide terrorism. However, there are also some problems can be shown in the drone mission in the Middle East and the Guantanamo prisoners. So it draws international-wise concern. So if I am a lawyer in the United States, how should I do my best to keep that the executive still keep its face on the Constitution regarding terrorism? Thank you.
Excuse me, if you allow me just to translate that. 那么刚刚这位同学其实提到一个相当有趣而且敏感的问题，他说现在全球对于反恐都有一定程度的一个 抗争或者是进行对战的共识。那在这一波的反恐战争的浪潮里面，美国其实一直以来就有不同的声浪。有一派认为说，他应该给行政的机关更多的权力去对抗恐怖分子，但同时也有一个问题是，身为律师，你应该如何的去面对像是在美国关达纳摩湾这些战犯的一个各种不人道措施的这种发现的事实里面，你要担任什么样的角色？那么他想就这一点来请教Iscoe 法官。
That is a very difficult and sophisticated question. Now I know why I was told that the students are so smart and well educated.
那么当然这是一个非常艰难的问题。那现在法官也知道说，为什么今天他知道说这个在场同学素质非常优秀。
The terrorism issue is hotly debated in the United States. And go ahead.
在美国，其实反恐战争跟恐怖主义的对抗一直是一个受到热烈辩论的一个问题。
Precisely what it means is being determined by the Supreme Court now, and whether the Patriot Act intrudes too far into people's rights.
那么其实有关于恐怖主义跟反恐战争这些东西的定义，其实目前在美国最高法院一直是一个很重要的议题，他们正在做不同的认定。而事实上，包括了像是美国著名的爱国者法案，也一直以来都有许多的检讨声浪。
Whether the treatment of prisoners in Guantanamo in Cuba is proper is also a subject of debate and legal challenge.
那么当然，刚刚我们提到，在古巴的这个美国的关塔纳摩湾军事监狱，对于这些战犯或者是战俘，他的一个不人道处遇呢，也一直以来是一个辩论的议题。
A friend of mine who teaches at Georgetown Law School brought a case that led to the release of a prisoner at Guantanamo.
那么事实上，法官本身就有一位在乔治城大学法学院教书的教授朋友，他也把一个案子带到法院之前，也因此导致了一个战俘呢，在受到这个不人道处遇之后，终于被释放。
And this is not my area of expertise, but I can tell you that the pursuit of terrorism and what is proper and improper under the Constitution will be decided by the Supreme Court following the rule of law.
那么虽然说反恐法这部分并不是法官个人的专长，但是他有信心告诉各位，所谓恐怖主义、反恐战争以及相关这些这些辩论议题的定义呢，将会在最高法院依据法治的原则之下做出决定。
So we don't know all the answers, but I'm confident that people's rights will be protected.
那么虽然说目前我们还不知道所有答案，但是法官很有信心说，他认为最终这些人的权益会在宪法之下获得相对的保障。还有第二个问题是吗？对不起。
Some back there. Somebody way back.
.那我们知道在美国陪审团制其实只有大概10%进入陪审团的制度，90%是用协商的制度。那我们律师在这个情况下，该如何去在这个正义、公平正义与当事人的利益中扮演怎么样的角色？
你讲刑案对不对 ？Okay. The question basically is. He wants to know that, we understand that in the United States, despite the case that in criminal cases, there is a jury system. But based on his understanding, only 10% or less of the cases actually enters into a jury system kind of trial. Other than that, over 90% of the cases are actually goes into the plea bargaining system. Yeah. So he's wondering, basically, being an attorney or a role of a lawyer, what should they perceive? How should they do to perceive this situation correctly, and what should they do to help to carry out the justice?
Okay. The questioner is quite right that most criminal cases in the United States do not go to trial. It is well over 90% in which a defendant pleads guilty.
那么事实上，刚刚这位同学讲得非常正确，在美国确实在刑事案件部分，可能有远超过90%以上的案件，并没有进入陪审团审判，他们采取认罪协商的一个状况。
But here's what the lawyer does. The lawyer looks at all of the evidence. He determines or she determines whether it was seized constitutionally.
那么，但是呢，一个律师还是有很多东西可以做的。例如说，第一件事情，他必须谨慎地检阅所有的卷宗证物，然后决定这些卷宗证物里面的取得或者搜索扣押是否合于宪法上的规定。
The lawyer advises the defendant on whether to go to trial or not.
那么接下来，这个律师依据他的专业，应该对他的当事人进行咨商，告诉他的当事人他的专业意见是否应该采取陪审团审判，或者不要比较好。
And the lawyer negotiates a plea bargain. Many times, people take a plea bargain because the penalty is so light that it is not worth the risk of going to trial.
那么接下来呢，如果受到当事人的一个认可决定的时候，这个律师就可以开始跟检方去进行所谓的认罪协商，因为很多时候当事人或许并不认为进入陪审团审判是对他最有利的状况。
But there are also instances, I hope very rare, in which people plead guilty even though they're not guilty because they are afraid of the penalty they're facing.
但是也有这样的状况，也就是当这个人其实并没有真正犯下他被指控的罪名的时候，他们为了害怕受到最高或最重的刑罚，依然在法律面前做出了认罪的答辩。
The lawyer's job is to make sure that that doesn't happen, that the client knows all of his or her rights, is effectively represented, and raises every legal challenge so that they have the opportunity to be fully represented and fully protected by the law.
那么各位在这样的例子里面，当然律师你最重要的职责是，第一个，你必须告诉你的当事人所有他的权利是什么，尽力去为你的当事人做出最好、最热诚、最竭力的辩护，并且确保他知道他所面对的是什么样的状况。Actually, Mr. Jerry Chang actually got a question. He was wondering, how come there are, articles about the jury system explicitly put down in the United States Constitution, and twice actually? What is the background of that?
Okay. Jerry Chang asks about the jury system and why is it in the Constitution? And actually, the jury system is in Article 3 of the Constitution and also in Amendment 6 and Amendment 7.
那么事实上，刚刚郑律师有问到说有关于美国陪审团制度的背景啊。那么法官这边讲到说，确实在宪法里是有明文规范的，包括宪法本文第3条以及修正案第6跟第7条。
Let me first read Amendment 6 says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury.
那么首先呢，是第6修正案有关刑事陪审团的规定。这个条文的规定大概是说，在所有的刑案里面，被告都有权利面对一个公正迅速的陪审团审判。
And it's not just for criminal cases. Article 7 says.
那么事实上还不止于刑事案件，第7修正案也提到。
It says, in suits at common law, where the value in controversy shall exceed $20, the right of a jury trial shall be preserved.
那么第7修正案也提到呢，在美国的民事制度底下，因为美国是采用所谓的普通法体系的国家，在普通法诉讼里面，只要案件系争标的的价值超过$20以上的话，那么这个当事人双方就有受到民事陪审团审判的权益。
It also says, no fact tried by a jury shall be otherwise re-examined by any court of the United States other than according to the rules of common law.
那么他也附加了后面的一个规定是说啊，任何经过陪审团所认定的事实，均不得由任何法院以任何形式做重刑的检视或决定，除非法有明文。
What that means is if a jury decides one thing, a judge can't decide something else unless they're following particular pre-existing law.
那么这是什么意思呢？这意思是说，如果在一个案件里面，陪审团已经针对某一个争点做出了结论或者判决，不管怎么样，法官都不应该去推翻这个法律的决定，除非法律上另外有明文的规定。
The Constitution also says the trial of all crimes shall, except impeachment, shall be by jury.
那么下一个这个修正案也说哈，所有刑案或者是犯罪的审判都应该受到陪审团的一个审判。
And such trial shall be held in the state where the crime has been committed.
那么这个陪审团审判的地点应该在犯罪发生地之州，由陪审团审判的形式进行之。
So why is that right to a jury trial in 3 different parts of the Constitution?
到底为什么陪审团制度会这么重要，以至于宪法要写3遍？
It's because when the United States was founded, there was a basic distrust of the king and of people in power, including a distrust of judges.
那么这最主要回归到在美国建国之初，当时的人民对于君王以及掌权者，甚至对于法官，有着非常基本的不信赖。
And the idea was judges might decide things in favor of the rich and powerful.
当时的情况是呢，很多人都认为法官有可能因为这个人是比较有地位的、有权势或者有财富的，而做出对他有利的决定。
But if criminal and civil matters are decided by a jury, then it will be the people who are deciding, not the powerful.
但如果今天把刑事或民事的议题交由陪审团来做审判的时候，那么基本上就是由人民来对于事实做出认定跟判决。
So you can see the jury trial is a basic part of our justice system.
所以各位应该可以理解，陪审团制度乃是美国司法制度的一个核心而且基本的一个要素。
And I want to give a recent example of the importance of having a jury decide something.
那么我希望跟各位分享一个最近发生的一个重要案例。
You probably have heard of the Boston bombing, where there was a bomber at the Boston Marathon and killed several people.
那么各位可能都有在报纸上听到，在美国波士顿马拉松举办期间发生了一个爆炸案。
There were 2 phases to that trial. There was what they call the guilt phase, to determine whether the person on trial actually committed the offense.
那么这个审判呢，大致上来讲可以分为2个阶段。第一个阶段是所谓的论罪阶段，也就是决定这个人犯的是什么样的罪行。
And then after the jury found that he committed the offense, there was a second phase called the penalty phase.
那么如果陪审团认定他有犯了被控的罪行之后，就会进入第2个阶段，也就是所谓的科刑阶段。
And you might say, but Judge, you just read us from the Constitution. I don't see anything, I didn't hear anything that said that the jury decides the sentence.
但是这时候各位心里可能有个问题，你会说，法官你刚才念宪法给我听，我并没有听到宪法里有任何依据可以给陪审团科刑的权利。
And you're right. There's nothing in the Constitution that says that the jury decides the sentence. And in all cases other than death penalty cases, the judge decides the sentence.
那么事实上各位的想法是正确的。事实上在美国呢，除了死刑以外的任何案件，陪审团都没有决定刑罚的权利。
But in about 1992, the Supreme Court said the death penalty is different. It represents community values, and it should be imposed only by a jury because the will of the people and the decisions of the people are so important.
那么，但是因为死刑有它的特殊性，主要来自于在1992年最高法院有一个案例，在这个案例里面呢，他认为说，由于死刑这个议题是如此的重要，因此呢，在这个刑度的决定上，只有人民基于群体的意识，有权利对这个议题做出判断。
So that's why the jury decided it. The jury had the power to decide. But the question is, why do I think it's important that the jury had that power?
那么，所以各位了解了为什么在死刑的议题上，陪审团有权利做出死刑的判断。
And the reason is, if the judge had heard the evidence and chosen the death penalty, many people might think, well, the judge works for the government. He's just making the decision the government wants him to make.
为什么把死刑决定的权利交给人民是这么的重要？因为最主要的原因在于，很多人会觉得法官是帮政府工作的，所以当法官依据证据下一个判决的时候，很多人可能心里怀疑说：“你是依据政府的意志去做这样的判决。”
And when the jury decided to impose the death penalty, people said, well, I guess what he did was really horrible, and the people thought it was the appropriate penalty. And even people who don't like the death penalty had to say at least it was decided by the people after hearing the evidence.
那么，如果这样的科刑判决是由陪审团所做成的话，至少人民会认为说，这是我们的社会群体或者我们的人民同侪所做成的判断。这个时候，哪怕这些人并不喜欢死刑的存在，他们依然可能必须要尊重作为人民群体来决定刑期这件事，决定死刑这件事情。
And I should say, I'm not a fan of the death penalty because I think it has been used disproportionately against the poor and against minorities and African Americans and other minorities.
那么法官在这边想跟各位强调，他个人并不赞同死刑的存在，特别在司法现况上，死刑大部分被用在针对所谓的少数族裔以及比较低下的社会阶层上。
But I'm confident in this case that the defendant had all of his rights protected and that the jury made the decision that it believed was proper.
但法官却愿意相信，在这个波士顿马拉松爆炸案里面的审理过程呢，被告的权益应该有得到法律上的保障，而人民也依据证据做出了决定。
And if the jury had decided against the death penalty, I also would have been confident that it made the decision that it believed was proper.
那么当然，如果人民今天的判决是说不要有死刑的话，法官依然会支持陪审团的决定。
It wasn't the decision that mattered as much as the fact that the jury made the decision.
重点就是，并不是结论是不是死刑很重要，而是到底是谁下的决定，这件事情很重要。大概这样。
Thank you. 谢谢。